Ship arrest and the Malaysian Admiralty Court. Maritime cases often involve issues of international law. The carriage of goods across nations separated by sea is often done by shipping lines of various nationalities. For instance, goods exported from Korea to Malaysia may be carried by a Japanese shipping line. Issues of international law abound when the sales contract apply Korean law and the bill of lading apply Japanese law. When the ship collide with the Russian ship in the Strait of Malacca and the parties are called upon to provide a general average bond, what is the importer to do? Who is he to claim from? Welcome to the realm of maritime law and conflict of laws. This is a realm maritime lawyer are familiar with. It is crucially important that the judge or arbiter is able to understand the legal and technical issues involved in these maritime cases. In Malaysia, the importance of having a specialist admiralty court gained impetus from needs of the industry, and this culminated with the setting up of the court in October 2010. A common order issued by the court is the warrant of arrest. This warrant, once executed on the vessel, will prevent the vessel from leaving the court jurisdiction. It is a powerful remedy which can result in quick settlement or the sale of the arrested vessel. The Malaysian court is based in Kuala Lumpur and operates as a specialist court within the commercial division of the Kuala Lumpur High Court. Since its assumption in October 2010, the establishment of the court quickly became an important support to the growth of the maritime sector in Malaysia. The court has since its assumption rapidly become an important adjunct to spurring the growth of the maritime sector in Malaysia. The industry quickly embraced the court as a preferred means to resolve shipping disputes, as the court possessed several important attributes. In line with an arbitration-friendly stance, vessel can be arrested in aid of intended and ongoing arbitration. The appointment of an admiralty judge means that the cases will be heard before a specialist arbiter who better appreciate the industry and the technical aspect of a shipping claim. The realm of admiralty practice, with its in-rem procedure and technical aspect, isn't easily understood by generalist judge, and the industry and shipping lawyer no longer have to delve into the basic of the law every time a shipping case is argued. The other attribute that is appreciated by the users of the court is that the court operates within a 9-month deadline in which the court will strive to complete a trial from the date of the filing of writ. The other apparent benefit of the court is that there are nominal costs, as the only cost parties need to incur are the court filing fees. Thus, the court offers plenty to litigant, as a specialist judge, speed and cost. These benefits were traditionally only found in the realm of arbitration. Admiralty jurisdiction under the court exercises the same jurisdiction and authority in relation to matters of admiralty as is for the time being exercisable by the High Court of Justice in England under the UK Supreme Court Act 1981. Traditionally, the Admiralty jurisdiction was limited to hearing claims falling under Section 20.1 and 2 of the UK Supreme Court Act 1981. Under the Admiralty Court practices direction, the categories of cases that can be heard by the court was expanded from the 18 categories of Admiralty matters within 24B of UK Supreme Court Act 1981 as applied by the Court of Judicature Act 1964 to include the following: claims relating to carriage of goods by sea, limitation of action for maritime claim, including action seeking to limit liability or for extension of time where the limit of liability or the time for commencement of proceeding is prescribed by maritime convention or legislation. Dispute pertaining to marine insurance and reinsurance contract, including marine insurance agent and brokerage contract. Dispute arising from shipbuilding agreement, including issues with regard to the construction, design, maintenance, and repair of ship. Dispute arising out of the sale and purchase of ship. Civil claim arising out of marine pollution, marine or shipping related agency, freight and multimodal transport, and warehousing of goods at any port in peninsular Malaysia. Claim related to ship financing and documentary credit for the carriage of goods by sea. Death or personal injury, loss or damage arising out of a marine activity in or about a marine facility, which includes port, docks, berth, or any form of structure defined as a ship under maritime law. Civil claim arising from any breach of any marine regulation, notices, bylaws, rules, or guideline. Dispute pertaining to the welfare of any seaman, including wage and contract or safety, and application in connection with maritime arbitration, including application for the preservation of asset pending maritime arbitration and the review, setting aside, and enforcement of maritime arbitration award. Appeals in respect of a maritime claim are determined by the subordinate court. The expanded jurisdiction allows for the specialist adjudication of the court to be applied to shipping-related activities such as marine insurance and freight forwarding and will spur the growth of the maritime-connected activities, which now has an important specialist venue for dispute resolution. Invoking in rem jurisdiction, ship arrest, the court accepts the filing of both in rem and in personam writs or action. Under the expanded jurisdiction of the Admiralty Court, where the defendant does own vessel or where the claim doesn't concern an unidentified vessel, the case can be initiated by the filing of an in personam writ. Where the claim involves a substantial Malaysian ship owner, the filing of an in personam action will be sufficient as there will be adequate resources within jurisdiction to levy execution without a ship arrest. A distinct feature of the court and admiralty jurisdiction is the invocation of the court's admiralty jurisdiction. This is invoked whenever any party intends to proceed with the arrest of a vessel. Traditionally, this is applied for at the court in the jurisdiction where the vessel is located. The court jurisdiction isn't limited to the geographical jurisdiction of the Kuala Lumpur High Court, but is within the whole of peninsular Malaysia and the Federal Territory of Labuan. Thank you.